Talk Show.
Recorded live.
Hello, ladies and gentlemen. This is Rod. This is going to be an update on the status of the P.A.G. There is a group that is working on getting P.A.G. webinars set up. And this is also an update on the International Tribunal for Natural Justice. Let me get into the International Tribunal of Natural Justice first. Ladies and gentlemen, due to the Washington, D.C. case, with the amount of knowledge that was put into this case, unlike a lot of your cases out there that you've done, those who have followed me on this whole D.C. case knows that we hit them at every level of jurisdiction of how they slide from one jurisdiction to the next jurisdiction. We brought up the fact of the Constitution. We brought up congressional records. Now, that is different than congressional acts. Congressional records is what is actually sitting in as records like McFadden was talking about, Ed Lindbergh was talking about. These are congressional records. These aren't acts, these are records. We brought in the records. We actually brought in Acts of Congress, 1902 Dick Act. We brought in the National Firearms Act of 1934, the Gun Control Act of 1968, the Firearms Owner Protection Act of 1996. We brought in the International Organization Immunities Act. We brought in 49 SPAT 3097, Treaty Series 881, Conventions and Duties and Rights of the States, which was a treaty, and we also brought treaties into this case. We brought in their own statutes at large, which was the written law. We brought in their own code of federal regulations, which was their administrative regulations. We brought in the United States Code, but we also brought in the Federal Register of 1935 and the Industrial Recovery Act of 1935, showing that the United States codes were assigned to the administration for their regulation through these acts. We also set forth their own administrative procedures. We set forth their own rules of court. We set forth their own trust laws under equity and their jurisprudence under equity. Due to the amount of this knowledge that has went in is what has got the international side, because this international side was developing long before I even got into this court in D.C., long before that. So it wasn't a process that my D.C. court developed this International Tribunal for Natural Justice. This was in the works long before the D.C. come into this. But because of the D.C. case, this now draws international attention to the corruption of our court system. What they are doing is they are developing a procedure here for the United States. They are developing protocol here for the United States. This has already been implemented in several other foreign countries in small areas, and it has worked pretty successfully. But because of the D.C. case of us coming back in and showing through acts of Congress at different levels is that we went from a government prior to 1867. Then we went to, in 1867 is when the federal government come in under that Reconstruction Act and forced all of the southern states to take on federal citizenship at gunpoint. That's historical. That's where the 14th Amendment came in 1868. Because if you go down and read Section 2 and 3, it only deals with public offices, and that is very significant. In 1871, they created the District of Columbia. They created the city to be the corporation. But they come out and used Article 4, Section 3 of the Constitution. Now, Article 4, Section 3 allowed them to create a state between a state or out of two states, where they could take two states and create a third state. There was nothing in the Constitution that allowed them to build a city and to incorporate it and then set the entire government inside that corporation, city limits. This is where the issue's coming in. So they went from a regular state government to a federal government, from a state citizen to a federal citizen under the 14th Amendment, to a corporation, because they built that corporation within two states of Maryland and Virginia, and the Constitution only allows them to create a state, not a city, not a corporation. But in 1945, they went from that corporation to an international under the UN. These people expatriated. They left their state national, left their sovereignty for an international. This is why if we want to sue them, this refers back to Title 28 under 1602 to 1611 under foreign sovereign immunity. They are claiming to be foreign sovereign immunity for us to sue them. But this also goes back under the Administrative Procedure Act, that we have to go through the legal process of going through the proper channels first in order to get a tort claim. And that same thing with a tort. You got to go through the proper agencies first. You got to go and notify them. Ladies and gentlemen, some of the basics behind this international tribunal, it is not going to be a fact that you have a issue with a public office or a department out on the street, and then you're going to take them straight into the international court. That isn't how this is going to operate. And I want to set you straight on that now. From the discussions that I've been involved in, is that they asked what would be the best way to handle this. And I said, this has to be in an administrative side. In other words, before you could take them into the international court, you would have to exhaust some administrative remedies out here first. In other words, it's like we sit here and talk to the Administrative Procedure Act. You have to go to that department. You have to bring a claim. You were damaged. They have to either reject it or cure it. If you're involved in a court case, this is where the knowledge come in of what I used, is the fact that I've walked them through their entire jurisdictional process. Even though I never walked inside of a court, and this is the whole point, you've got to dump paperwork into these people. You've got to address them with paperwork. And it has to be done at the time of your initial stop. It has to be done at the time of your, not the day I show up in court. It has to be started at your initial stop. That's where a lot of you are making your errors. You're waiting till court date. What do I file in? You should have been filing it in all along. Because this is where you go after your administrative remedies. This is where you go in and you file in against the agencies, and you put it on the record. This is where you go in and you start addressing their own rules, and this is what I've sitting here and told people, know their rules, know their job, and that job means their job description. Where do I find this? Look under your own state statutes for that job description. This is what I did here in North Carolina for the Sheriff Department. I went in and found their duties. What's the duties of the Sheriff Department? Their duties is to be a bailiff. Their duties is to run the county jail. Their duties are to sit down and serve paperwork on the orders of a court, which would be a warrant, a summons, a foreclosure, a writ. I never seen anything in there that says they are allowed to sit out on the street to detain, arrest, kidnap, and Shanghai. That is not part of their job description. This is what I'm sitting here saying. Know their job. What's the job of a judge? A judge, where do you find his information? Well, you go back to the fact that he was a bar agent. What is the oath that they took as a bar? They sit here and swore that they would not mislead, misrepresent, misconstrue, put false information. All right, but under the judicial rules of canon, he is to be impartial, unbiased. Under Title 28, he is to sit down and not practice law from the bench. Know their job, know their description. Understand their words. That's another one. This is what we turned around and did. Well, Mr. Clash, you're being charged for a firearm. Excuse me. I did not have a firearm. I had a pistol and a rifle. And I just found it under the Geneva Convention here of 1864, 1906, 1949, in 1955. The Geneva Conventions classify a pistol and a rifle as small arms under the Geneva Convention. These are small arms. They're not firearms, they're small arms. There's a big difference in wording. Same thing with the word automobile and vehicle. Ladies and gentlemen, you have to understand their words. And you have to use the correct verbiage in that courtroom. Those of you that are running under trust law, then you guys know that you cannot actually come out and use their own statutes, but on the other hand, there's nothing that sits here and says purported by your regulations under 26, section 5845, or your purported regulations under 27, section 479.11. I didn't use USC codes. I didn't use CFR. I sat down and said purported by your regulations. And I named the title in the section without naming USC codes or CFR. But this international tribunal is being set up as a people's court. It's being set up for you, the people, with the assistance of a P.A.G., and we're going to get into that, for you to be able to bring a claim, but you first have to exhaust your administrative remedies. This isn't a process of they pissed me off, so I'm going to take them in. No, you have to show that you made the effort here to solve this. Or even if you was in trial to where you made the effort to resolve this, even at your own hearing, and they overruled and denied everything. Some of you people are going to get one shot at a courtroom hearing. Just these traffic and civil cases, they just drag you in, and wham, bam, thank you, ma'am. This is why you have to get your paperwork in prior to your court date to get it addressed. And when you walk in there and the judge says denied, now you've got a legitimate reason to bring them in before the ITNJ. Because you've now exhausted your remedies, because you put the proper paperwork before that court, and that court overruled everything. You now have exhausted your remedy. This now violates human rights violations. This violates the executive order that Bill Clinton had when he signed into the UN of human rights violations and involuntary servitude or involuntary slavery. This international tribunal that is being set up, like I said, it was done internationally. It wasn't done here in the States. They are working on protocol for the United States. What we are looking at is there's going to be several different hearings involving several different groups. One is going to be an administrative process, which is the first hearing, which is to bring forth your complaint and for a panel of 3 international judges to sit on it. Now, there could be a 4th, and that fourth would be here in the United States in that courtroom. And the function to where if they are part of the three, then they would be part of the decision making. If there is three international judges and a fourth, that judge is to keep decorum. That judge is to keep the ability to write writs, warrants, summonses, subpoenas, to sign these so they can be served. This way it doesn't have to go overseas and wait for weeks for it to come back. We would have one sitting here that's qualified that can sit here and take care of these small issues. While the three panel would be the decision making and the administrative side. That would be the first side. The first side would be a process of proving that there's enough issues for it to be heard and to be addressed. If there is not enough evidence, then the case will be dismissed. If you put in enough and you actually prove your case, what they're talking about is having this go before a grand jury here in the United States. This is why we're trying to get grand juries up. There's trying to be a grand jury set up, and they are developing. The defendants will have the opportunity, and I am pushing for this, is that they would be allowed to go before the grand jury and justify their actions. Now, in some cases, there will be multiple defendants. Only one defendant out of that multiple. If you get more than two, one will be chosen to be the spokesman, not both. If you got 6 or 7, not 6 and 7, one. That one will have the opportunity to administratively to defend the other members. If they are found guilty, then they will have the opportunity to pick another one of their members to go before the grand jury to speak on behalf of them in the grand jury and let them explain and justify their actions at that courtroom before the grand jury. We're going to give them an opportunity that they have never given to us. What they've done to us is held secret grand juries and handed them a ham and Swiss sandwich. Says, is this a ham and Swiss sandwich? Yes, it is. Okay, he's guilty. That's all we need to know. The grand jury that's going to be set up is going to have the opportunity to ask questions. They're going to have the opportunity to investigate. And this doesn't mean they go on a fishing expedition. They will have the opportunity to hear both sides, then make a decision. So even if they're found guilty in the administrative, the grand jury could possibly set them free. Now, let's sit here and say that the grand jury don't set them free. They're looking at a third hearing. Again, if they have multiple parties in this thing, they have to pick another one, because if the first one didn't work in the administrative hearing and the second one did not work in the grand jury hearing, they will have an opportunity to put a third one in before the international court, which would be crimes against humanity and involuntary servitude. Technically, this is going to come down to a small Nuremberg trial. They're going to be charged with war crimes, crimes against humanity, crimes against slavery. This has worked in other countries. People, you are going to have to grow a backbone. You are going to have to sit down and start standing up, and don't sit down and say, well, I'll let somebody else do it. We have let somebody else do it, the Bar Association. At some point, you are going to have to risk something on your side of this fence. Like it or not, want to or not, you want your freedom, you're going to have to risk something. Like we talked here the other night, this is no different than the Founding Fathers. There's a very thin line between traitors and heroes. If you lose, you're a traitor. You will be tried as traitors. If you win, you will be heroes. This is what the revolution brought on is the fact that it created possibility a section of traitors. If they would have lost the Revolutionary War, they would have been tried as traitors. But because they won, they were American heroes. Ladies and gentlemen, we're at that same point in time right here, right now. This international court, for some of you who want to sit back and say, okay, Rod, where is their jurisdiction? What gives them the authority to walk into this country? Let's start with that, okay? I will agree with that, and you have every right to ask that question and to know that. Let's, you and I, go back into the Constitution, and I don't care if you want to sit here and say, well, Rod, you are talking corporate Constitution. Get over it. Because whether it's the organic or whether it's the corporate Constitution, it says the same thing. And let me read it to you. Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution. The laws of the United States and treaties. Did you hear the word treaties? And treaties made, or which shall be made, under their authority in all cases affecting ambassadors or other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party. Controversies to which the United States shall be a party. Let's go back and look at that 49 Stat 3097 Treaty Series 881 Conventions and Duties and Rights of the States. You go back and read that act and that treaty. That treaty defined the United States as a state. The UN treaty defines the United States as a state. Canada as a state. So keep this in mind. To which the United States shall be a party, a controversy between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands and grants in different states, between the state or the citizens thereof, foreign state, citizens or subjects. That is one section. The moment they sit down and use the word treaty, that brought the International Tribunal in here. Because there is treaties being made. The United States is part of several treaties internationally. Now, let me go read you something else. Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything to this Constitution or laws of any state to the contrary notwithstanding. Again, it falls back under treaties. These people are running us under treaties on how they are running this. This gives this international court jurisdiction under treaties. They're going to have to rewrite the Constitution, not the Bill of Rights. They're going to have to rewrite the Constitution. They can't. Even under their own corporate guidelines. If you want to be really dogmatic about this, well, Rod, damn it, it's a corporation. Fine, their own corporation sit here and said they have to abide by treaties. Either way you look at it, they're bound by treaties. This gives the international court jurisdiction under treaties to deal with the corporation and their employees. So it doesn't matter which way they want to run with this, whether it's the organic constitution or they want to sit down and jump up and down. Well, this is a corporate charter. Well, this is a corporate charter. Fine, your corporate charter says treaties, and you're making treaties under that corporation with all these nations. So as a corporate charter, you're making treaties. You're bound by these treaties. And if you are violating these treaties, then the International Tribunal has jurisdiction. Ladies and gentlemen, this is not going to be this hard. But this is some of the procedures that we're working out. They're coming to me, and we're walking through some of this stuff. This international tribunal, if it gets off the ground in this country, and there's supposed to be a first hearing on June 15th this year, supposed to be a first hearing on June 15th this year. That June 15th hearing is going to set the standard for all future tribunals in this country. Ladies and gentlemen, it's going to take you to get involved. It's going to take you to be the backbone. It's going to take you to help donate finances into this. It's going to help you donate your time for right now into this, to be a party to this, to be members of a grand jury. But getting back to that third court hearing, like I said, the first hearing would be administrative. It would be 3 international judges. It's going to be televised. It's going to be televised. The one judge that sits in there would be a neutral judge on our side for the United States. That judge would have the ability, like I said, to sign summonses, warrants, subpoenas, to keep it from having to go overseas. They will contact the overseas judges, and they will sit down and agree, say, yes, go ahead and do it, and they'll sit here and sign. The next one would be the grand jury. That third one would be with one international judge, whether it would be the one here from the United States or whether it be one from overseas and the United States judge sitting here to keep decorum. But there will be a jury selection. There would be a jury selection on this. We need people available for jury selection in different states. That is going to be a necessity. We don't have the ability to go out and pull a driver's license and pull this. We have to have a jury selection set up, and people have to volunteer for jury selection. So whatever state we are in, we got people in that state for a jury. Now, whether you're part of the grand jury, that's fine. If you've got a bunch of members as part of the grand jury, the 12 people who did not hear the case can sit on a jury, that's fine. But we're going to need volunteers for jury. That case will be presented before a jury, not the judge. That judge will remain neutral on the international side. The opposing party will have their opportunity to go before that jury and justify their actions. They will have the ability to justify why the Constitution doesn't apply to the courtroom. They will have the ability to justify why the private citizen representing himself is not allowed to file paperwork in, and why we are not allowed to defend ourselves in that courtroom because it's only relied for lawyers, which is violation of the Taft-Hartley Act. They will have the ability to explain to the jury why they can charge you with a statute as the injured party. They're going to have the opportunity to justify this to you. They're going to have the ability to sit down and justify their entire action in that courtroom. As a jury, you will have the ability to sit down and make your own decisions. It isn't going to be a process where the judge is going to tell you, well, ladies and gentlemen of the jury, there's only one decision you have to make here. Are they a judge? Are they an attorney? And that's the only decision that you have to make. And if it's yes, they're found guilty. That judge isn't going to be able to sit down and do this. That judge is not going to be able to sit down and interfere. It is going to be up to you, the jury, to make this decision. This is where you're going to have knowledge of their rules. You're going to have knowledge of their job description. You're going to have knowledge of their verbiage. You're going to have to be knowledgeable. You're going to have to be able to read the evidence that gets put before you from both sides. You as a jury are going to have the burden on your side of guilt or innocence, not based on the fact that they are a judge, not based on the fact that they are lawyers, but based on the fact of the evidence of misconduct and procedural violations. This is the intent and what we're trying to get organized for procedures and protocols for this international tribunal. They've already been recognized internationally. We're trying to get more funding up. We're trying to get more people involved for volunteering because, ladies and gentlemen, this is our country. This country belongs to us. What we have is a labor management dispute. We're management. We are the employers. They are our employees. Hence the word public servant, not public masters. There is a difference in that last word between servant or the word master. These people will be tried by a jury of their peers. Their peers is their masters, not their colleagues. We are a jury of their peers. We are their masters. We are their employers. This is how it's supposed to be. Like I said, otherwise it would be called public masters, not public servants. Understand the verbiage difference. Now, let's get into the P.A.G. side of this. I talked to a gentleman here last night called Anthony Williams and what he's doing. And it sounds like he's doing some great, great things of getting judges recused off the bench. And a part of it is because of the grand jury. Part of it is because he is having grand jury members walk into all these court cases and announce themselves that I am grand jury number so-and-so. I am grand jury number so-and-so before the court. He is walking in with members of militia. Ladies and gentlemen, we need militia members. This is going to be part of the enforcement. We need militia. We need federal marshals that actually understand the rule of law in the Constitution, and FBI agents that understand the rule of law, that is willing to sit down and say, okay, you people, finally, you people finally got a court that represents the people. Now we can operate and help to restrain those that are operating in a corrupt fashion. Because the problem we had before that is they had no place to take them. And that's what I've been told. We have no place to take them. Now there's a place to take them. Now, for the P.A.G. side, that's what we're sitting here saying. Anthony Williams, with what he's doing on the P.A.G. side, he's walking in. And he made a statement last night, and it's very, very true. And I've tried to explain this about myself. What's it take to be a P.A.G.? Knowledge is part of this, understanding. The other aspect of this, ladies and gentlemen, is knowing that when you walk into that courtroom, you're going to go head-to-head with the judge. Knowing that you're going to go head-to-head with the opposing side. A lot of people got knowledge, but they lack the ability and the willingness to go head-to-head. You don't have to be arrogant. I wasn't, because when I was up for my sentencing hearing, and I was asked for my allocution, and I made issues that, look, prosecution on his page 3, second sentence from the bottom, sit here and made a comment that He now hopes that Mr. Class will learn to follow the laws. Well, my comment was, Your Honor, what law am I supposed to follow? After all, I had a carry concealed permit. My stuff was registered. Your property wasn't marked. We brought in the Constitution, we brought in congressional records, we brought in statutes at large. What law am I supposed to follow? Oh, that's right, we're supposed to follow theories and concepts. Well, what's the theory and concept for today? Where's the books for theory and concept? I wasn't being nasty, but I was sitting here talking very straight up. Ladies and gentlemen, I want to remind you people of something. Carl has made this comment several different times, and he's right. We, him and I, have never once been charged for being a private attorney general or a bounty hunter. That isn't what I was charged with. In fact, that they charged me for a gun charge was stupid on their part. But I do have an appeal getting ready to be started. And right now, they're sitting on my paperwork. They don't know what to do with my notice of appeal and my informa pauperis. However, the public defender did call me and ask me if I was going to have him represent me. I laughed at him. I said, why would I want you? He said, well, Rod, what's going to be your appeal? I said, I can't tell you that. He said, well, why not? I said, because you're going to be a snitch, and you're going to go tell the other side. So I ain't telling you shit. But ladies and gentlemen, being a P.A.G. is not just about knowledge. It is about going in and standing your ground or going in on behalf of another party. Because not all people are capable of standing up and speaking. Being a P.A.G. is being able to walk in for that person before a court and speak on their behalf. And ladies and gentlemen, we got case law on that. You've got under civil rules, procedures, Rule 17, under G, authorized by statutes. You've got 29 CFR 2200.22, intervener, and 2200.23, entry of appearance. We've got case law, and we have got rules of court that says you and I can walk in. The fact that they don't want to abide by it is the issue of this international tribunal. But we're going to need private attorney generals. I would like to have several per state. I don't know how many cases is going to come up in this international tribunal, but I do know on June 15th, if it goes according to schedule, we're going to have our first hearing on June 15th this year. The day that the Magna Carta, 800 years ago, was signed by the king. I would like to get this thing set up, and so would they, that we could have several different hearings across this country at one time. And I ain't talking hundreds of thousands of hearings. I'm talking if we can get 3-4 hearings set up within that same month, get them scheduled. Like I said, the first hearing would be the administrative. This is where you would come in with the assistance of a P.A.G. that would assist you, unless you can do it on your own. But you would have to go and contact a P.A.G. in order to get a hearing set up. Ladies and gentlemen, if you want your freedom, this is an avenue. Again, it's like I said here and talked to some of you out here before. Congress gave us the ability to be private attorney general through the 1866 Act, through Title 42, 1988. Congress gave you and I that authority. They gave us that because it is our right. The International Tribunal comes in under Article 3, Section 2 under treaties, Article 6, Clause 2 under treaties, under executive order that Bill Clinton come up with. And let me pull up that executive order, because he signed it into law for human rights violations against against any country or against the United States, that they cannot violate human rights in this country internationally. So this gives the International Court subject matter jurisdiction to hear this case. I'm still trying to pull up the executive order. But ladies and gentlemen, there is enough information here that what we are coming up with. All right, Clinton's executive order for human rights is 13-10-7. It's 13-10-7. It was done in 1998. The Geneva Convention was 1864, 1906, 1929, 1949, 1955. That's international treaty. International Organization Immunities Act. International. Key word, international. 49 stat, 3097. Treaties. There's that word, treaties. Ladies and gentlemen, this is what gives this international tribunal authority to come into this country. Because this stuff was put in my paperwork in D.C., this is what led them to contact me due to the paperwork that I filed in. This is what opened up the door for them to come into this country. Because they've been trying to find a way to get in here and they never knew how. There's an opportunity, ladies and gentlemen, for you to sit down and start standing up for your country. You want your freedom back? This is an avenue. We need enforcement. We need militia members that's willing to come forward to be law enforcement, which is what they were originally intended for, because if you go back and understand the historical side of this country, it was the militia that helped defeat England. They are working on the sheriff department under Sheriff Mack, appointing constitutional sheriffs into this for enforcement. They are talking with these people. They are talking with other agencies without the United States and some within, that if the people will get their act together and there is a court that could be convened for the people, that they may be willing to step forward now, because there is a court now that can be used to correct the system. Up to this point, there is none. Up to this point, the bar attorneys control this. Here is an opportunity for the people to take the court system back. Here is an opportunity for us to turn around and start changing this country. And I don't mean for a short time. I mean for a long term. This, what we are doing, we're going to have to continue for generations to come. This thing will eventually get up through the ranks. We're not just dealing with judicial, but we're going to start be dealing with other branches of government. The success of this falls back to us. What are we willing to sacrifice? What are we willing to sit down and risk? Ladies and gentlemen, I think the fact that I only got nailed for a $350 fine, which is nothing more than court cost, and a year of supervised probation, or supervised release. Let me take that word probation off. Supervised release, because I'm not on probation, and they made that very clear. I'm not on probation. I'm on release. Says a hell of a lot for what I did to that court system on standing up and hammering them with their own procedures and rules, and hammering them under all their different jurisdictions, and proving the fact that the court did not have criminal jurisdiction, because there's nothing in the books that gives them criminal jurisdiction other than they bring us in as alien enemy residents. And we proved that under the birth certificate. I didn't lose, ladies and gentlemen. They may have had the last say, but I did not lose. They had to show their absolute corruption. And that's what got the international court interested, is they showed absolute corruption. The absolute of human rights violation. The absolute of involuntary servitude. The securitization of the birth certificate. Extortion. They didn't beat me. I may have got a year supervised release, a $350 fine, but because of this international court has now been given jurisdiction to come into this country because of what we laid out in our paperwork, gave them subject matter jurisdiction to now come into this country and start running the people's court in this country. So did I lose? You figure it out. But ladies and gentlemen, it's going to take us to stand up. It's going to take us to stand up to become P.A.Gs, to be able to willing to talk in. And there's a lot of you that may not have all the knowledge that I have, but you are knowledgeable enough in your area that where you're dealing with foreclosures, that's basically all you have to deal with. But you're going to find out, being a P.A.G, it's not going to be that hard in this international court. It's not going to be that hard. It isn't going to be what you think it is. But we're going to need jury members. We need people to volunteer for jury. And I will get some contact information out. And if you will go over to the itnj.org, I believe it's .org. Let me look it up here once. But if you will go over itnj.org. Okay, that's what you want. It's itnj.org. Contact us. All right. There is an email contact with a couple names on there. Sue Rhodes and Nadine Black. Contact at itnj.org. Get your name in for jury selection. Tell them what state you're from and the county. Give them full detail. They have a donation button for donations. Right now, we are working on international donations, get international help on some of this stuff. We've got other organizations that we're trying to get because it's going to take money to fund this thing. I've been involved in a lot of things out here, but most of the stuff like rap, that was internal within our own people. Because this ITNJ is external, and they have used some of this and developing it, and they have developed it in other countries. This is what it's one reason why I am jumping on behind this. As I said, the International Tribunal for Natural Justice is an invite of Humanitat and New Earth Trust. The ITNJ has formed an alliance with the Emerging People's Human Rights Authorities to serve as a venue for their independent prosecution to bring cases before an international tribunal committee to open and transparent proceedings and the principles of natural justice. Ladies and gentlemen, like I said, this is something that I am involved in. This is something that I am working on. This is part of the reason why I've cut down some on my shows, because I am involved in some of these international calls of what we're doing. I am on calls with these people. I haven't abandoned AIB radio. I've had to take a break here from the house from what we were doing, because, ladies and gentlemen, the knowledge on there, I have pretty much gone as far for knowledge as what I can go with you people. You're going to have to pick up the ball. You've got enough information on AIB radio that if it was applied to a college credit, you would have more than a degree in law than any attorney out here. You would have more of a degree than any attorney out here. You would have more knowledge than any attorney out here, and you're one little pinky finger than they would in that bar association. The knowledge that we're dealing with here is plain simple language. It's common sense. These courts don't run underneath this, but this tribunal will. It will run under natural law. It will run under common law. It will run under human rights violations. And the one advantage that we would have is that you are the human whose rights have been violated. not some artificial entity, not some fiction. You are the human who had your rights violated. Therefore, because of that, you have standing to bring a claim. This is the significance of this. You have standing to bring a claim. You have the right to bring a claim. But like I said, we have to exhaust our administrative remedies first on our side of the fence before we can take them into the international. And as P.A.G.s, that's one thing we're going to have to be very dogmatic about. Did you file paperwork in the case? No, then you don't have a claim for the international court. You have to show that you brought forth a claim. You have to show where you have addressed and the judge denied. Well, the Constitution don't apply to this courtroom. The laws don't apply to this courtroom. Then what the hell are you bringing me in here on? Theories and concept is not substantial evidence. It's substantial means of dragging you into a courtroom because I have a theory. I have a concept. And these people need to remember something. The statutes at large are written very precisely. When they sat down and wrote these books under publishing, under West Publishing, they changed the terminology. They changed the intent. This is a law office or a law firm that is writing this up for the publishing company to publish it in such a manner that it changes the whole context and the intent of the law. Ladies and gentlemen, you're the backbone. You are the ones who are going to have to address this. You're going to be the enforcement. And I told you that people that long time ago, quit looking for somebody else. We are going to have to be the enforcement. We need the militia up and running. Once we get this international court, and like I said, June 15th is supposed to be his first hearing. We need enforcement. We need militia to contact the itnj.org, get a hold of contact people, and register yourself for enforcement, register yourself for juries, register yourself up for P.A.Gs. The choice is yours. Freedom or tyranny, slavery or being a master. That choice is yours. Thank you. You guys have a good day and have a